Good morning, ladies and gentlemen. It's really big pleasure for me to be here. Thank you for Turiba University for hosting this nice event, and really it's quite challenging and quite different to participate on-site events in those difficult pandemic time. And of course, thank you for other partner university for friendship, for collaboration during this great project. I think that we experienced a lot of nice things together, and we sincerely hope that all the materials are really good and really important for our lawyers and mediators to develop their communication. So today I have a short presentation on the topic mediation advocacy. I'm ready to provide 5 tips for a greater success. Actually, both professions need to collaborate very much in order to reach the settlement agreements, and both professions need to know each other very well in order to be successful. So this time my presentation will be about advocacy, but I hope that during this event a lot of information will be for mediators as well. So I'm going to start with a quote from Lincoln, and it actually inspires, I suppose, everybody to search for the settlements. So it was written really several hundred years ago that discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the real loser in fees, in expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man, and there still be business enough. So, lawyers at mediation. So I suppose it's like everyday thing nowadays, and despite of the fact that effective mediation of course requires personal attendance, but still parties to a dispute are participating with attorneys together, and it becomes really usual practice. And in countries where mediation do not have all tradition, as we noticed in Latvia and Lithuania, Dana also presented results of our survey. So in Lithuania and Latvia, we still are suspicious about working together, mediators and lawyers, but in other older mediation tradition countries, definitely it's like normal practice. And in our countries, we still feel that there is a lack of common understanding of the lawyer's role in the process. And so my presentation will focus on what is the objective of mediation advocacy, how mediation advocacy should be performed, and what are the mistakes which should be avoided. So, objective of mediation advocacy, I like very much this quote that mediation advocacy is the skilled technique of presenting and arguing a client's position, needs, and interest in non-adversary way. And the main objective of mediation advocacy, I will give you a short test to try find solution maybe. You know, when lawyers are saying, okay, let's try that mediation, it will be no bad consequences, let's see. Or to see how the process of mediation will go. So let's go to the process and just see maybe other party will make a good proposal and maybe we will settle. So also it doesn't feel right, yes? And another option is to settle, just to have a mindset that I'm going to settle and I'm going to help my client to settle. So I suppose that this is correct answer. I hope that we will have possibility to discuss it. And it is not about winning, definitely. It's not about being the best negotiator, it's being peacemaker. So main functions in mediation of attorneys, definitely you will find a lot of more materials in our recommendations, but still the main thing, so definitely it's education of the client. So attorney at law is that person who can provide really good information about the mediation and explain everything for the client. So that's good before the process. Preparing the client for the mediation as well, it's a very important thing because mediation as negotiations definitely needs to have a good preparation. Assistance to the client during the mediation, not replacing the client during mediation, but assisting him. Preparation and evaluation of draft agreements, all legal matters, Appropriate formalization and legalization of the agreement if it is necessary, and client counseling and support in the post-mediation period. That's also very important because we need to enforce settlement agreement, and that's okay if it is voluntary, but sometimes we need to have like legal support in order to get the settlement performed. So first tip for successful mediation advocacy, I suppose that it is very important to have a different mindset when you are coming to the mediation to compare with a battle in the courthouse. So what is helpful? Familiarity with the mediation process and main principles of it. So we see that education power is very, very big, and those attorneys who know well what is mediation and what are the main principles of this process, definitely they perform better during the mediation, and their clients are getting more settlements. Also understanding that only collaboration leads to success of mediation, not competition, but collaboration. Knowing that legal argumentation is not a cornerstone here. Sometimes during my mediation processes, I'm like seeing attorneys who are trying to somehow argument for the other party and other lawyer that legal arguments here are the most important thing. But actually in mediation, we're looking for the interest of the people, and sometimes that law even has no importance at all. Ability to motivate client for his commitment to work hard for the settlement. Attempt to mediate may never be interpreted as a sign of weakness. In Lithuanian how to say, maybe mentality, sometimes that suggestion to search for the peaceful agreements might be seen from opposite party as a sign of weakness. Because like, you are coming and asking me to settle, so maybe you do not have money for the court, maybe you do not have courage to argument your position and so on. So definitely it's a wrong mindset and it's necessary to change it. And changing aggressive, arrogant behavior to showing empathy and understanding, even if your legal position is strong enough to win the case in the court. So the purpose of the court is the purpose of the advocacy in the courthouse is to convince the judge. In mediation, it's necessary to convince opposing party and her attorney. So definitely it's more difficult task. Another tip, maybe choose right mediator. And here we can talk a lot about various criteria, but I think that several of them should be just taken into mind as most important. Expert of the field or mediation expert. Of course, we can discuss all day long about it because there is a different attitudes towards this thing. But I suppose that when we're coming to the mediation, we're expecting professional who will help us to communicate. And if that professional only has a big, deep knowledge in the field, is not so helpful to compare with his facilitative skills, with his communication skills, which might be helpful for the parties to facilitate their communication. Mediator as an authority or as a communication facilitator. Some people are thinking just that I need a judge to mediate, I need a best attorney at law to mediate just because of that knowledge and of course because of that authority, that he or she will know better how to settle. But mediation about settlement between the parties, so definitely their interests are the most important thing. Neutral mediator or opinion provider. So I strongly believe that evaluative mediator, who just takes that evaluative mediation style, is not neutral anymore. So here it's necessary to answer that question, what kind of mediator I need here, neutral or that person who will provide opinion. Minimal basic training or solid continuing education. I know that in Latvia as well in Lithuania we have like quite low hours for becoming mediators. In Lithuania we have 40 hours, and those mediators who are practicing a lot already know that after these 40 hours when you start working, actually you understand that you know nothing and you need to search for some continuing education. Logistics and fees, definitely it's also worth to know. In some situations there is cases where mediator is assigned by the authorities. In Lithuania, we have mandatory mediation in family disputes. So here it's very important for us. And just my wish is to send a message that from the side of lawyers, it's that appointment of the mediator should always be accepted with a respect and trust, because if in very beginning of the mediation there is doubts about the competences or professionalism of the mediator, it doesn't lead to success. One more tip, preparation for the mediation. So there is a certain must-do list for the lawyers. So as providing information about the process, presenting possible results of all available processes, just assess what is better, mediation or litigation in commercial disputes, maybe arbitration. Assessing the time, financial and emotional resources required for each of the process. That's also is very, very important. Decision to mediate or not, of course, is discretion of the party. So here also sometimes we feel that parties are not willing to mediate, but lawyers are strongly believing that it will be good. So of course, it's good that lawyers have such kind of opinion, but definitely the final word should be done by final decision, or mediating or not should be done by the client. And during the preparation for the mediation, right before the mediation, it's necessary, of course, to agree on cooperation rules. Like lawyer and his client should talk about it and even should settle rules. For example, the basic rules is not to sign any documents until they have been reviewed and evaluated by an attorney. And actually, the lawyer must ensure that the client's decisions are taken only after he has been informed of all possible consequences. So that's very important. And it's also possible to discuss in advance who will be more active during initial stages of the process, who will speak during the initial speech, and so on. And even rehearsal of initial statement of the part is highly recommended. Another thing which is important, I suppose, it builds the trust. So parties to a dispute do not trust each other. It's normal, they are in conflict, but especially they do not trust each other lawyers. Somehow they even demonize the lawyer of the other party because it's something cruel, something really aggressive, arrogant person, because he or she will protect the interest of other parties, which are definitely not reasonable and not just. So good mediation attorney should strive to build a trust-based relation, of course with a mediator, but as well with other party and other party's attorney. What to do? Of course, use power of empathy, respect, nonviolent communication. So empathy here for building trust should be used by active listening. It's not only the skill of the mediator. Attorneys should also employ that skill and use it during the mediation. Striving sincerely to understand the situation and perspective of the other person. Regretting about the situation and being sensitive about the emotions of everybody in the room. Being grateful for the chance to mediate and committed to settle, and etc. So accusations, aggressiveness, and purely legal argumentation are the weapons of the courtroom, not the mediation. So practical advice, it's important even before the mediation to manage expectations of the clients, because sometimes when client is not ready for different behavior of attorney in the mediation room, client is like stressed because his attorney starts to regret about the situation, start to apologize even, start to be really kind and sensitive. So definitely it's necessary to talk about these strategies in advance. And the last thing, it's very important for the attorneys, but as well it's very important for the mediators. Do not rush the solution. I'm serving as a chair of exam commission in Lithuania, and we're evaluating the readiness of the candidates, mediators, to start their professional activities. And the main mistake I have noticed, together with my colleagues, that mediators are rushing the solution. So even when we are hearing the initial speeches of the parties, some mediators are asking, okay, but how you would like to settle? So definitely, if people know how to settle, they would do it out of mediation room. So they are coming here in order to investigate, in order to find those different interests, and only after it find possibility to settle. So every season has its own fruit. So mediation stage has its own purpose. So Of course, it's a very structured process, and that there is no need to rush for the solution too early. And it is normal that first hours of the mediation do not focus on developing the most suitable solutions, even first meetings in some cases. So mediator together with parties performs investigation, which will end only after the disclosure of all interest of the parties. It takes time, but drives to better understanding and change of the perspective. So rushing the mediation does not lead to time saving, because sometimes it's saying, okay, let's save time, what you are proposing to me. It doesn't work. It normally leads to failure. So let the mediator to manage the process in its own manner and employ all your listening skills for hearing what is important for the parties to a dispute. It dictates solutions, which will be discussed later, and parties will be ready to discuss it. So also that do not rushing the solutions is very important at the very, very end of the mediation. The principle of voluntariness is relevant in the very end of the process, and parties to a dispute are free to settle or not. So there is no need to rush them with this decision. Even if attorneys are happy with the results of negotiations and recommend to sign the settlement agreements, parties should be awarded with time to make the decision and commitment to enforce that decision, to perform it voluntarily. So peace must have enough time to grow. So to sum up, mediation advocacy means helping clients to develop ability to cope with conflicts, supporting parties for restoring their relationship, working as a teammate with mediator and other lawyers. So a respectful mediated dialogue is the fastest way to restore collaboration and mutual understanding. So let's hear each other, respect each other, and commit to settle all our conflicts peacefully. Thank you very much.